The facts of the case is the Royal Calcutta Golf Club contested an appellate authority order. The Calcutta High Court noted that the appellate tribunal under GST is yet to be constituted. Our revenue argued that the proviso applies only prospectively and offers no relief for prior periods. It's a case relating to Madhya Pradesh High Court. Mahendra Singh versus Assistant Commissioner State Tax and others, 64.89 lakhs tax, interest and penalty was found to be non-speaking order. The facts of the case is, since the assessee had approached AAR, that is Authority for Advance Ruling, Sonu Monu Telecom Private Limited, through its director Jitendra Gar and others versus Union of India, Bipartite Act requiring actual transmission to the assessee. Unlike, the court emphasized that permitting composite orders would prejudice the assessee's statutory rights. GST Outlook for the week. GST Judicial Outlook number 1. My dear friends, this is a case with respect to Calcutta High Court judgment wherein Royal Calcutta Golf Club versus Senior Joint Commissioner of State Tax, Behala Circle, Kolkata and others, WPA 22906 of 2024. In this, it was held Calcutta High Court to examine Rule 88B proviso disallowing ECL, Electronic Credit Ledger, adjustment against interest liability for delayed filing. The facts of the case is the Royal Calcutta Golf Club contested an appellate authority order requiring payment of interest on the entire tax liability, including portions already paid in cash. The Calcutta High Court noted that the appellate tribunal under GST is yet to be constituted, leaving taxpayers without an effective appellate remedy. The court examined the proviso to Rule 88B of the CGST Rules 2017 as amended, which restricts interest liability to net cash payments, aligning with taxpayers' contentions. While the 53rd GST Council meeting recommendations formed the basis of the amendment, our revenue argued that the proviso applies only prospectively and offers no relief for prior periods. Observing a prima facie case and balance of convenience in favor of the taxpayer, the court stayed the impugned interest demand and directed the exchange of affidavits for further proceedings. It was held in Royal Calcutta Golf Club versus Senior Joint Commissioner of State Tax, Behala Circle, Kolkata and others. My dear friends, GST Outlook number 2. It's a case relating to Madhya Pradesh High Court. Mahendra Singh versus Assistant Commissioner State Tax and others, writ petition number 5186 of 2025. It was held in the High Court. AAR not binding on distinct GSTIN or businesses under same name quashes the non-speaking order. The facts of the case is the court clarified that an advance ruling under Section 103 of the GST Act applies only to the applicant and not to all the assessee, we know well, and its jurisdictional officers. Hence, the ruling in Gulab Singh Chauhan could not be automatically applied to the petitioner, who had a distinct GST registration and independent business entity. My dear friends, the adjudicating authority erred in mechanically applying the Gulab Singh AR ruling to the petitioner instead of independently assessing the petitioner eligibility under the GST law. The revenue argued that as the petitioner firm was a sister concern of the Kanavat Pan Group operating under a common brand, the AAR ruling against Gulab Singh should bind the petitioner. The court rejected this stance, reiterating the legal individuality of GST registration. The demand order imposing 64.89 lakhs tax, interest and penalty was found to be non-speaking order, since it merely stated the petitioner's reply was not satisfactory without any reasoned analysis. My dear friends, setting aside the impugned order, the court remanded the matter to the Assistant Commissioner of State Tax, Indore Circle 1, directing a fresh independent adjudication of the show cause notice on merits, uninfluenced by any external advance ruling. It was held in Madhya Pradesh High Court, Mahendra Singh versus Assistant Commissioner State Tax and others, writ petition number 5186 of 2025. GST Judicial Outlook number 3. My dear friends, the case of GST Delhi, that is Principal Bench, DGAP versus Mallikarjuna Cinema Hall, 70 Hyderabad. My dear friends, it was held in this case, the GST held state cinema ticket price cap not a profiteering license. Orders Mallikarjuna Cinema to deposit. GST, that is Goods and Service Tax Appellate Tribunal, upheld DGAP's finding that Mallikarjuna Cinema profited 16.50 lakhs by raising base ticket prices despite GST rate reduction from 28% to 18% to 12%. The respondent's own admission that ticket prices were not reduced commensurately was treated as clear proof of profiteering. The plea that ticket prices were fixed under state rules and upheld by Telangana High Court was dismissed. GST clarified that while the Cinemas Act and government orders prescribe maximum ticket prices, theatre owners retain discretion within that limit and GST benefits must still be passed on. The 3 rupees maintenance charge per ticket was held to form part of the taxable value and its separate collection could not justify non-passing of GST rate reduction. Referring to Rekit Benzer case, GST retaliated that business or commercial considerations cannot override the statutory duty under section 171 to pass on tax benefits to consumers. My dear friends, applying the ratio in Procter & Gamble, GST held that interest at 18% under Rule 133 subsection 3 clause C is prospective from June 28, 2019. The only 3 days of the investigation period fell within its ambit and the interest applies accordingly. The profited amount with limited interest must be deposited into consumer welfare funds within 1 month. Held GST Delhi, DGAP versus Mallikarjuna Cinema Hall, 70 Hyderabad, NAPA bar 3 bar PB bar 2025. GST Outlook number 4. My dear friends, this is a case relating to Karnataka High Court, wherein NCS Pearson Inc. versus Union of India and others, writ petition number 7635 of 2024. My dear friends, in this case, the High Court has held the basis classification issue draft by Authority for Advance Ruling, Section 74 SCN, that is Section 74 Show Cause Notice, invoking extended period on same issue unsustainable. The facts of the case is, since the assessee had approached AAR, that is Authority for Advance Ruling, in January 2020, disclosing all material facts regarding GMAT Type 3 test, the court held revenue was fully aware of the transaction. Therefore, the sine qua non of willful suppression under Section 74 was not met. Accordingly, the court clarified that Section 74 cannot be invoked for mere non-payment of tax, incorrect classification, or wrong disclosure in returns unless accompanied by deliberate intent to evade. Accordingly, the classification GMAT Type 3 test OIDAR or not was itself in dispute, with AAR, Authority for Advance Ruling, and AAR taking conflicting stance and the issue still pending before the High Court. In such interpretative uncertainty, alleging suppression or misstatement was held unsustainable. Revenue's reliance on Neminant fabrics was rejected, with the High Court clarifying that the precedent applies only where suppression is established or admitted, conditions absent in this case. Given revenue's prior knowledge, absence of mens rea, and pending adjudication on classification, the SCN issued under extended limitation was quashed. The court emphasized that allegations of willful suppression were illegal, arbitrary, and contrary to law. It was held in Karnataka High Court, NCS Pearson Inc. versus Union of India and others, writ petition number 7635 of 2025. GST Judicial Outlook number 5. My dear friends, is a case relating to Delhi High Court. Check India Private Limited versus Assistant Commissioner CGST WPC 11718 of 2025. In this case, the High Court has quashed staggered refund processing, recognizes adjudication powers of the appellate authority under section 107 subsection 11, permits de novo adjudication. The facts of the case is the assessee challenged 4 orders in appeal, that is OIAs, and on refund rejections of unutilized ITC, highlighting inconsistent findings. Services to Czech Inc. USA were rejected as non-export in some cases, while partial refund was granted in another on identical facts. The refund claim related to software development, content development, ITES services in the EdTech sector provided exclusivity to the overseas parent company. Revenue denied classification as export of services. Accordingly, High Court retaliated, citing Sonu Monu Telecom that under section 107 subsection 11 CGST Act, the appellate authority can examine matters on merits afresh, including admitting documents not considered by the original authority. My dear friends, the High Court criticized the staggered disposal of refund application, which led to contradictory and irreconcilable outcomes, stressing that all refund claims should be considered comprehensively in one go. The High Court set aside the refund rejections and remanded the matter to the appellate authority for fresh adjudication with clear powers to confirm, modify or annul orders to ensure consistent treatment. Accordingly, my dear friends, this position was taken in Delhi High Court, Czech India Private Limited versus Assistant Commissioner CGST WP number C11718 of 2025. GST Outlook number 6 is with respect to Delhi High Court judgment Sonu Monu Telecom Private Limited through its director Jitendra Garg and others versus Union of India WPC number 2926 of 2025. My dear friends, the High Court has held no embargo for non-consideration of reply against composite SCN afresh under section 107 subsection 11. The facts of the case is the court clarified that the appellate authority can confirm, modify or annul the adjudication order, which includes examining the assessee's reply, evidence and reasoning afresh, making it a full-fledged first appeal. My dear friends, the assessee argued that only the adjudicating authority could consider their show cause notice reply under section 74 subsection 9. The court rejected this, holding that appellate review extends to the entire matter, including the reply filed before adjudication. My dear friends, the only restriction is that the appellate authority cannot remand the matter back to the adjudicating authority. This ensures finality and avoids repetitive reconsideration. Since the show cause notice contained detailed computation for multiple financial years 2017-2018 to 2019-2020, the court upheld its validity as a consolidated notice and did not find fault in clubbing different periods. The court relied on its my name decision, affirming that the expression confirm, modify or annul must be interpreted broadly, giving appellate authorities wide latitude to decide the appeal on merits. It was held in Delhi High Court, Sonu Monu Telecom Private Limited through its director Jitendra Garg and others versus Union of India WPC number 2926 of 2025. GST Judicial Outlook number 7 is with respect to Madras High Court judgment Sharp Tanks and Structurals Private Limited versus Deputy Commissioner GST Appeals and others WP MD number 24684 and 24685 of 2025. My dear friends, in this case, the Madras High Court upholding the orders in GSTN portal, not communication. Limitation for appeal filing begins upon effective communication. My dear friends, the facts of the case is the court clarified that the appeal period begins only when an adjudication order is effectively communicated. Very, very important. Only when the adjudication order is effectively communicated through recognized modes, post, courier or direct tender, not merely the date of uploading on the GST portal. My dear friends, Section 107 specifically uses the term communicated, which the court held to be a bipartite act requiring actual transmission to the assessee, unlike unilateral portal upholds that do not constitute valid communication. The court emphasized that the statute obliges the department to communicate orders. There is no statutory obligation on taxpayers to keep checking the GST portal for uploaded orders. While revenue relied on Pandidori Setupati Raja upholding valid service, the court preferred the line of reasoning in Shahul Hamid and Namasivaya Auto Cars. Uploading alone is insufficient, aligning in line with the Supreme Court ruling on fairness, Madhukar Kumar, discretion, Techno Prince, and practical interpretation, Southern electricity supply. Since the impugned orders were only downloaded recently by the assessee and had never been communicated per law, the court held they cannot be enforced until properly served. The office was directed to duly communicate the orders afresh. It was held in Madras High Court, Sharp Tanks and Structurals Private Limited versus Deputy Commissioner GST Appeals and others, WPMD number 24684 and 24685 of 2025. GST Judicial Outlook number 8. It is a case relating to Andhra Pradesh High Court, SJ Constructions versus Assistant Commissioner and others, writ petition number 11028, 11206, 17671 and 20792 of 2025. My dear friends, the High Court held bunching adjudicatory proceedings for multiple assessment years impermissible follows Madras High Court judgment. My dear friends, the facts of the cases, the Andhra Pradesh High Court held that a single show cause notice or composite assessment years cannot cover more than one financial year. It cannot cover more than one financial year or tax period under the GST law. My dear friends, while Delhi and Bombay High Courts earlier allowed composite orders across years, Karnataka, Kerala and Madras High Courts disallowed them. Accordingly, Andhra Pradesh High Court aligned with Madras High Court interpreting any period in section 73 subsection 3 as linked to such tax period in section 73 subsection 4 was provided. The court reasoned that the Delhi High Court in Ambiga Traders had not examined the interplay between section 73 subsection 3, section 73 subsection 4. It held the Madras High Court's approach restricting assessment to specific tax periods to be correct interpretation. The court emphasized that permitting composite orders would prejudice the assessee's statutory rights, including filing separate appeals under section 73, 74 and availing penalty waiver under section 128. The impugned composite orders were set aside, but the revenue was given liberty to initiate fresh proceedings for each tax period separately in compliance with law. It was held in Andhra Pradesh High Court, SJ Construction versus the Assistant Commissioner and others, writ petition number 11028, 11206, 17671 and 20792 of 2025. GST Judicial Outlook number 9. It is a case of Allahabad High Court judgment relating to Safecon Life Science Private Limited versus Additional Commissioner Grade 2 and another, writ tax number 389 of 2023. My dear friends, the High Court quashing section 74 proceedings rebukes dealers' harassment under guise of fraud to invoke extended period. It's a much needed judgment. My dear friends, the facts of the cases, the court reiterated that section 74 of the CGST Act is applicable only when fraud, willful misstatement or suppression of facts with intent to evade tax is established. Mere suspicion or reliance on unverified intelligence cannot justify invoking this provision. My dear friends, relying on Continental Foundation SC, the court stressed that suppression and willful misstatement under fiscal statutes necessarily involve mens rea. Absence of intent to evade tax makes section 74 inapplicable. The revenue's denial of ITC based solely on an intelligence report without sharing the material or recording findings of fraud misstatement was held to contravene principles of natural justice. The assessee's reliance on invoices, e-way bills, transporter documents, banking transactions, GST and returns substantiated the genuineness of purchases, countering revenue's contention that supplier irregularities justified ITC denial. My dear friends, referring to CBIC circular 13/12/2023, earlier ruling in Kurja Scrap Trading Company, the court observed that Section 74 should not be misused to harass dealers, reaffirming that GST was designed to promote ease of doing business, not create procedural hardships. Accordingly, it was held in Allahabad High Court, Safecon Life Science Private Limited versus Additional Commissioner Grade 2 and another writ tax number 389 of 2023. That's all for the week. Signing off, Advocate Dr. M. Sathya Kumar. Thank you.